I'm going to share our slideshow with you because the attorneys that you see here are part of this story. So this is Welcome to Business Law 101, Part 3, Leases and Contracts. We discovered as we were preparing for this presentation that basically we are going to talk about leases because, as you will see in the story, we will have several lease issues coming up. So what is this story? The story is that we have some young entrepreneurs, well, maybe not so young as I've been just told, but here is Marta Stewardess. She is a graduate student at the Polytechnical College in San Francisco. It's fictional. She's studying chemistry, expecting a PhD, and her favorite movie is Sideways. Here's her favorite wine, and her hobby is winemaking. We have Brittany Spearstein. She's also a graduate student, field of studies, computer science and business, expecting an MBA and an MA at the end of this year. Also, her favorite movie is Sideways, and here's her favorite wine. She likes to cook and pair her recipes with wine. And we have Myra Estefan. She's also a graduate student studying electrical engineering, expecting a master's at the end of this year. Her favorite movie is also Sideways. Here's her favorite wine. And she's studying also, in addition to electrical engineering, to be a sommelier, specializing in South American wines, which is where she's from. So the story is that Marta had this idea to refine the winemaking process, building a device, a little widget that would continuously monitor the key chemicals during the winemaking process and use a sophisticated software algorithm to determine exactly what quantities of which ingredients to add at what times during the process. Brittany worked with Marta to refine the algorithms and develop the software code for the device. Myra produced the hardware design for the device, inserted the chemical probe into the wine vat, attaching it to a computer input and readout device, and built a crude prototype of the device in the school's engineering lab. Brittany then programmed the device, and then Marta, that's going to be me, tested on her next batch of homebrewed wine, and the results were very good indeed. So then we dubbed this device the Sideways Winemaker and began holding dorm parties featuring the Sideways wine, SiWi, made using the Sideways Winemaker. Myra designed a cute little label and put on SiWi, put on the year when this wine was made. Brittany created a little web page. Everything is cute and little, right? Where she described the delicious taste of the Sideways wine created using the Sideways Winemaker. And then word got around and other amateur winemakers began asking about this winemaking device, if they could purchase one. And we wanted to set up a business and became very excited. However, as Myra was graduating and had a nice job offer in New York City, she wanted to pursue that job offer, so she wished us best luck and left. Then we scrapped together some funds on our own and received a nice $20,000 seed funding from Brittany's parents to start up the business. And now we are organized as an LLC and receive further seed funds from an angel investor who shall not be named. And we are looking to lease an office space, a winemaking space, and the manufacturing space. So we need 3 different facilities for our operations, as we will have an office to handle orders and marketing, and sales. We will have the winemaking space where we make Sideways wine, and we will manufacture the Sideways wine widget, which we named the SiYY. And then we went to see the lawyers. Today we have 2 fantastic lawyers with us. Lubna Jahangiri, who is the principal of the Jahangiri Law Group, There is the website, and you will receive this. She has over 20 years of experience in a variety of business and real estate transactional and litigation matters. She graduated top of her class at Golden Gate University, and us as San Francisco college students, we felt a kinship with her. She serves on the Discovery Facilitator Committee of the Contra Costa County Superior Court, and in her past life, she worked in the field of mental health and among other things was the clinical supervisor of the Bowman House, a drug and alcohol rehabilitation facility for pregnant women and women with young children. And we would also like to make the point that our wine should be consumed responsibly. Wait. I lost the slide.
That's okay. You can totally pass over me. I'm not hurt.
I'm not going to pass over you. I'm going to stop the share. I'm going to tell you everything about Myra. So Myra has 30 few years. We are not talking about our age of commercial real estate transactional experience. She has her office in the Oakland Hills. And she has done this before it was cool to do so, as nowadays we almost all work from home. And she's a fantastic authority on commercial leasing and is a co-editor of 3 separate CEB volumes on leasing. I don't know what happened to my slide, but I'm mildly miffed. So here we are today, and we are asking, here I am today because my co-entrepreneur Brittany is in Napa negotiating a deal with the winery. So we're very close to going commercial. We really need to get an office space. We really need to get the winemaking space, and we really, really urgently need to get to manufacturing because these Napa wineries are at our threshold asking us to manufacture this device. They want to get started this autumn, and after the harvest, they want to use our device. So we have a very short, mere 5 months timeline to get everything, all our duckies in order. So no pressure, ladies. Tell me, what issues should Brittany and I consider when we are negotiating our lease? Lubna, why don't you get started with this?
Well, first of all, commercial tenants unfortunately don't have the same protections that are afforded to residential tenants. And landlords almost always try to get the tenants to waive all the other statutory rights under California Civil Code. But the flip side of that is that most of the provisions in a commercial lease are negotiable, and they should be actively negotiated. Most business people, when they start a business, they only, in my experience, look at the rent and the monetary and the financial obligations of a lease, but they kind of gloss over the rest of the clauses, which can turn into big disputes that I also handle on the litigation side. So that's the number one advice, is to look through all the provisions and actively negotiate. And it depends on the leverage of the tenant. So if it's a newer and a smaller entity who's a tenant, the landlords will almost always want a personal guarantee regarding all the provisions of a lease. And because most leases are written by landlords on their paper, they are one-sided. I mean, most of them are one-sided. And even if they try to balance it out, they still are skewed in favor of the landlord. So that is the number one advice that I would give a startup company such as yours. And then the lease should address all the terms of the lease, and anything that's not in writing doesn't exist. So proper description of the premises, rent, permitted uses, base rent, additional rent, how the rent will increase over the term of the lease, any options, who is responsible for what will happen in the case of a breach, and how will the lease terminate.
I would also, if I could piggyback on that, with regard to the rent, which is of course extremely important to any tenant. In the context where you have a wine widget company, they're likely going to be looking for sort of a blend of flex, maybe R&D space with some office, some warehouse, and capacity to do fulfillment. And that type of building, it's very, very rare that they're going to be able to get what's called a gross lease, where they pay the monthly rent and that's it. At minimal, they'll be looking at an industrial gross lease where they're paying common area costs and operating expenses and increases over the base year in the landlord's taxes and insurance. And they may also have a triple net lease where they're essentially responsible for everything from day one. So it's key, if they look at nothing else in the lease, to fully examine and understand everything that the landlord can charge them, ask for a history and estimates of how much that will be, have an attorney look at it, because there are things they can negotiate away or limit, like capital expenditures. And yeah, I guess that's, one other thing I wanted to say is to, at the letter of intent stage, raise the issue of property tax increases if there's a sale of the building. Tenants very rarely think of that. Then I get a letter of intent and we get into the lease language, and, oh, this landlord's owned the building for 40 years. It's a family asset. The owners are aging. The next generation wants to sell it. And, the pass-throughs could go up exponentially because of the tax increase. So as Lubna said, a tenant, especially a startup, may not have a lot of leverage to negotiate that, but you have a far better chance of maybe negotiating some sort of a cap or some sort of an ease into an increase if you bring it up at the letter of intent stage and not at the lease negotiation stage.
So you mentioned option. I assume that's option for leasing more. We would be interested in maybe, getting more square footage if we grow and hire more employees, and especially if our manufacturing grows. Myra, what would you say about that?
Well, there are various ways you can approach expansion rights if you're in a multi-tenant building. Again, this is a bring up at the outset issue, but you can have a first offer right, where if space becomes vacant, the landlord has to tell you that, and you start a negotiation process. You have a period of time to try to agree on the rent. Alternatively, or in combination with that, you can have a right of first refusal where, before the landlord can sign a lease for the space with a new tenant, they have to offer the same terms to you. Landlords are not usually fond of that because it chills their ability to market the space if they have to first get a deal in hand and then bring it to an existing tenant. So I'd say you'd have better luck just trying to get the landlord to tell you how much the landlord wants for the space and have a first offer right to take the space. Be aware that you're going to have to wait until any existing tenant that's in that space you want, they may have renewal option rights. You won't be able to negate those. You'll have to wait and see if they exercise the renewal or not. But then if they don't, then hopefully you should get first crack at it.
Right. Lubna, do you have something to add here?
Yeah, so what I would just briefly add that once that has been negotiated and become part of the lease, then also just be sure to include the exact square footage and the flooring plan. In other words, the exact space that you have the right of first refusal to. And then also the rent, will any TI allowances be applied to that with the same terms and conditions of the lease applied to the additional space, etc. So all that should be negotiated and added to the lease.
Okay, thank you. So you mentioned something in these terms about who is handling the repairs. I assume the landlord will want to come in periodically to take a look at the premises, but our winemaking system is a patented widget, and we have other trade secret processes, and our client list is also a trade secret. So can we restrict the landlord's entry onto the premises, and how do we make sure when they come in to repair that they do follow our, confidentiality requirements? Lubna.
Myra, go ahead. You were going to
Okay,
say.
I was just going to say that in my experience, it's extremely difficult to get landlords to give up their access rights, or even to require them to give you more than a day or two notice before they want to come in. So I think your best approach here would be to get them to sign NDAs, non-disclosure agreements, acknowledging that you have confidential processes. And also, if there are certain areas of the premises that are more sensitive and off limits than others, to try and limit their viewing or entry into those areas to when there is a genuine need, like making a repair, or, maybe they have to inspect in connection with a sale, but not just, because they feel like it. But I think getting the landlord to sign NDAs and to require them to get the same NDAs from anybody that they bring in, any contractor, etc. You may also be, you mentioned the, coming into repair, and you might be surprised again for this type of space. It's typically the tenant who is responsible for all of the maintenance and repair inside the building, and often the air conditioning unit on the roof as well, and the plumbing in the walls and so forth. Typically, landlords will only be responsible for maintaining the roof and the structure of the building, again, unless you negotiate a different type of lease. But with the use you're contemplating, I would say don't be surprised if the lease you see requires you to be responsible for all of that. And that may address some of your concerns about the landlord not coming in to make repairs.
It does, but if they do want to come in for inspecting the premises, I will need them to engage with our personal protective equipment policy, because we are using semiconductors. So this is basically parts of our widget manufacturing is a sterile facility. So how do I do that, Lubna?
So you can negotiate a clause, and because you have a sterile environment, then the agents who are coming onto the premises on a non-emergency basis, you could require them to don protective clothing, masks, gloves. However, for emergency entries, I don't know if that would be possible, depending on the emergency. And most leases do reserve the right of the landlord to enter without notice in case of an emergency. So you may want to define what an emergency would be beforehand. Right. And also, I think one of your concerns was that you don't want the landlord or its agents to enter unless one of you is present on the premises.
Right.
And it's all about negotiating. It's all about leverage. And if you can negotiate that with the landlord and they agree, then that will serve the purpose, because you do have trade secrets. And the other restrictions that I've seen landlords agree to is the time limit. So they can only enter for non-emergency purposes, certain times of the day.
Right. So if we are typically out in the morning because we're going to Napa, we are going to Sonoma, but we are usually back in the office after 2 p.m., then we could negotiate that time for non-emergency visits, inspections, and if they have to enter to repair whatever they are required to repair, right?
Yes.
Okay.
And again, with a 24-hour notice. And I've seen leases in which the landlord has agreed to a 72-hour notice.
Mhm.
but nothing longer than that.
Yeah, I think even a 24-hour would help us. We can move our obligations around to just be present, but we need to be present because we need to make sure that our most valuable asset is protected, and it's currently secret. So the next question I have is, we have, as winemakers, we are using reagents and other, chemicals in testing the wine and in the winemaking. For example, we use pure alcohol when we are making our port. So we will be using flammable and sensitive chemicals that need to be properly stored. And we probably also need a chilled room for our bubblies. So what is it that I need to know regarding my lease here? Whichever one of you would like to talk.
Well, the typical hazardous materials section of a lease will require, a tenant, well, will initially prohibit a tenant from bringing any hazardous materials onto the premises. So knowing that you have specific things that you're going to need, you need to negotiate that at the outset. So there's a carve out for what you need, and you'll be required to store it, transport it, dispose of it, etc., all in compliance with laws. And the landlord will want indemnification. So if anything does spill and if there's any damage, the cleanup will be the tenant's responsibility. But that's nothing so far out of the norm. There are lots of, industrial and manufacturing and tech companies use hazardous materials. And it's simply a matter of, figuring out what you need to do as far as storage and disposal so that you don't run afoul of laws and have a spill. Lubna, would you add anything on that point?
Yes, thank you, Myra. So I did some research to see what type of storage facilities would a business like yours require, because you have to store not only the chemical agents, but also the wine once it has been processed. And it just depends. They're from small labeled containers to cabinets to special rooms, storage rooms that are constructed. So it depends on your need and what you intend to do. But my only advice would be to specify in the lease clearly whether a storage unit is considered an equipment or a fixture, because both of them are treated differently. And also consult a CPA to see what the tax treatment of each would be. And if it's a fixture, then it would be considered a trade fixture, which you can take away with you when you terminate the lease or when you're vacating the premises, as long as it doesn't damage the property. And the other thing I would add is that in the lease, it should be also clearly spelled out that in case the tenant is in breach of the lease, they still have the right to take their trade fixtures with them. Yes.
Right. I don't want to, if I buy an expensive cooling room, then I don't want to, have to buy another one because I'm late with the lease for 5 days. That would be absurd.
Right.
Thank you. That's very useful information. So suppose I need to bring in something that requires me to change the agreed upon footprint or the distribution of the rooms in my building. How can I do that?
So are you saying you need to like move demising walls, or I'm not sure I understand.
Yes. So we looked at the premises and they are fine, but we are considering for present purposes, but we are already looking at, maybe we will need to move some walls.
Okay, so that would fall under the alterations clause of the lease. And you're definitely going to need landlord consent for that. Typically, the standard is consent won't be unreasonably withheld. The landlord may want to approve your contractor. Sometimes they require a completion bond to make sure you don't leave something half done. They'll want to see plans. They'll want to make sure you have permits if they're required. So there'll be some hoops that you have to jump through. But leases typically do contemplate that tenants, especially if it's a long term, that at some point over the term of the lease, you'll need to make some modifications to your space. It's
Right.
just important to be mindful of that there is a provision in the lease about that, and look at it when the time comes and see what you have to do, how many days notice, for example, you have to give the landlord. The landlord may have the right to come back and require you to modify your plans if, for some reason it could adversely affect a building system, say. But it should be doable.
So what happens after termination? Can they make me restore the building in how it was?
Excellent question. And the answer is yes. And this is a hotly negotiated area in leases, because tenants typically do not want to have to do that. They also especially don't want to have to pull out like their cabling for their communications and all the wiring they put in. So the thing to do there is, when you're negotiating the lease at the outset, make sure you read carefully what it says about that. Some leases say that everything you put in has to stay. It becomes the property of the landlord. Other leases require a complete restoration. Some tenants want to take their stuff. Other tenants want to leave it. So it all depends on what the parties', respective goals are. And the important thing is that at the time that you ask for consent to make a modification, to know what it is you want at the end, and to ask the landlord at the time, can we remove this, or do we have to remove this, conversely.
Mm-hmm.
The lease should allow you to do that, to get a waiver of whatever the requirement is, leave it or yank it out at the time that you request consent.
So we need a crystal ball, or kind of be able to predict what we will need to do later.
Lubna, maybe you've had a different experience, but in my experience, most times, yes, but with the caveat that, everything is negotiable, even at the end. I mean, I wouldn't want to recommend to you that you leave it to the end. And I also don't know how successful you'll be at getting the lease to say, at tenant's option, you may leave it or take it out. But I also know that vacating involves a process where hopefully there's communication between the landlord and the tenant, and expectations can be expressed on both sides and something can be worked out. Well, what would you recommend, Lubna, if the tenant really doesn't know now what they're going to want as far as their alterations, but they want maximum flexibility?
Well, the default law, Myra, as you know, is that the alterations have to be removed and the tenant has to restore the premises to its original condition. I've never had success in leaving this question wide open at the discretion of the tenant.
Yeah.
Now, initially, I know there are some landlords who have offered TI allowances for the tenant, just as an inducement for the tenant to enter into a lease. They offer a tenant improvement or tenant alteration allowance, and then they give 3 months or 4 months for the tenant to complete the alterations. And then there's also sometimes the landlords, they add in a month or two free of rent, or until the business opens. And that's mostly for retail businesses. But all the alterations, I've in my experience, the tenants have been asked to remove them, because the alterations may not work for the landlord's next tenant.
Right. So maybe we can negotiate that we leave some of it and we restore some others. So for example, telecommunications, they may want to, if we did some improvements, then they may agree to leave that.
Also because the landlords have to consent, like Myra said, to the alterations, and they are actively involved in the whole process. So they approve the plans up front. So at that point, you may want to negotiate. They might be beneficial for the landlord and for their next set of tenants.
So here is another issue that's kind of on top of my mind now that we have this contract that we are negotiating with the Napa winery, is that we need to get some ABC permits, and usually they require that they would come and inspect the premises. But when we are negotiating the lease, the landlord says we have to have already the license to produce the alcoholic beverage before we can lease. So how do we cut this Gordian knot? How do we remain compliant with licensing requirements?
Well, licensing is the tenant's responsibility. And as Myra said earlier, when we were discussing it, that it is beneficial for the tenant to first research what laws you will need to comply with and make sure that you are in compliance at the outset of the lease negotiations. That includes zoning laws. You want to start a business in a building that is zoned for that particular purpose. But compliance with laws is tenant's responsibility, and it's almost always included in the lease, especially laws that regulate your business.
So can we secure the premises with the promise that we will obtain these permits before we start commercial operations?
I would say, if at all possible, you even want to try to get a contingency to your lease obligations that you can. I mean, if you cannot operate this business without an ABC license, then you don't want to have a situation where you're declined for the license for whatever reason, and you've committed to a 5-year lease. You'd be in breach by not taking occupancy, and theoretically you could be liable for the balance of the lease term with certain modifications. So to get around the catch-22, which it is, because you need a premises address. I'm not a liquor license expert, but I do know that you need an address to apply for your ABC license. And if you don't have a lease yet, then you don't really have any rights to access the premises. But I think perhaps a little side letter or a simple access agreement where, if you need to do an inspection of the property or something simply for purposes of applying, for your license, I think that would be something that would be workable with most landlords. I've seen that done.
So to what extent is the landlord responsible for the condition of the property? Because we looked at it and we think that there are some repairs that need to be made.
So the landlord, normally, they're not responsible for fixing the property at the outset of the lease for your use. But I think it's good practice to have the landlord in the lease represent and warrant that all the equipment is in good working condition and the premises are fit for your particular use. But after that, and Myra, you may have a different take on this, but in my experience, the landlord is normally responsible for structural repairs and maintenance, and the tenant is responsible for just ordinary wear and tear maintenance of its own premises, unless the structural defect or damage is caused by the tenant's negligence or intentional conduct.
I agree. And I typically see the lease, if you don't negotiate anything different, will say you're taking the premises as is by accepting possession. You're acknowledging that everything is just dandy. So again, at the letter of intent stage, and if you have a savvy broker, they will ask for, at minimum, building systems, plumbing, electrical, HVAC are in good working order. Roll-up doors, that's another thing where you get a funky door that doesn't, so roll-up doors should be in good condition. The roof should be watertight. Try to negotiate that representation will last a decent amount of time, like 6 months to a year, so that you have time to get in and get settled and get through a rainy season to see that everything is working. And lastly, I'm often able to negotiate a carve out, at least for latent defects, so that even if you've done your due diligence and gone and brought an inspector, if it's something that is latent that you cannot see upon an inspection, that shouldn't be a responsibility that you're taking on as a tenant. So those would be the ways I'd recommend to protect yourself from, big surprises with the property.
And the structural and non-structural elements also, that's sometimes the lines get very blurry. So for example, if the windows are cracking, that would look like a non-structural defect, right? It's just windows, replace the windows. But if it's a big tenant who's occupying thousands of square feet, it could be a very expensive project. And cracks in the windows can also appear because of foundational defects. So so the more details the lease has, I think the better it is for the tenant. And sometimes, especially for my nonprofit clients, I've been able to negotiate a ceiling that they are not liable for anything over a certain dollar amount by way of repairs and maintenance, even for ordinary use and wear and tear.
I thought that there was some legal protection for tenants.
Not in the commercial context. You have to negotiate your own legal protections. And I think a cap is the best way to do that if you can get one, because rather than arguing with the landlord, is it structural or not? Is it a replacement needed? Whose fault is it? Just, have the ability to say, look, if something is needed, our maximum expenditure in any year is X. Another approach I've had some success with is to say that, okay, if something needs to be replaced, or it's a capital expenditure within the tenant's obligations, let's say the pipes need to be replaced, that you amortize it over the useful life, and the tenant only has to pay every month that amortized portion, so that you're paying for it while you're there in the space. And once you're gone, because it is a building improvement, it's the landlord's responsibility for the rest of that, or to figure out how to pass the cost through to the next tenant. They think, oh, we have new pipes in this building, so the rent is a little more. But yeah, trying to get some protection, as I mentioned at the outset, this is the blank check part of signing a commercial lease if you don't know what you're doing and you're not careful.
So how can we make sure that the landlord will perform their obligation to repair and maintain, insofar as we have some repair and maintenance duties in the lease?
Well, ordinarily, by statute in California, you have the right to repair and deduct the cost from rent. But every lease you're going to see is going to have you waiving that right. Landlords say it's because their lenders don't like it. They can't run the risk that a tenant will not pay rent. But I think that if you have some leverage, either because you're an established tenant, which I realize SciY is not, or because you're leasing a lot of space, or for some other reason, maybe the market is soft and the landlord really wants you, you should be able to at least negotiate, a few notices like, hey, we're telling you something needs to be repaired. If you don't come in within 30 days, we'll give you one more final notice for 10 days, and if you don't, then we're going to repair it ourselves and start, deducting it from the rent. I think that if you push on that point and you give the landlord, plenty of opportunities and plenty of notice, you might be able to make some headway.
Wow, that's really useful tip. Thank you. So what if, and this is unfortunately on top of our mind in the past couple of years in California, there have been a lot of hill fires and wildfires. What if the facility gets damaged by fire and we have still many years left on the lease?
So there is no default law that requires the landlord to build or rebuild after the property is damaged, but in all the leases, I think practically all the leases that I've seen, there is a clause that obligates the landlord to rebuild under certain conditions. Right, Myra?
Yes, absolutely. There will be nuanced differences. Sometimes usually the standard is how long will it take to repair? And if it's going to take more than, say, 9 months or a year, the landlord will want the option to terminate. Or if the damage is uninsured, the landlord will want the right to terminate. The important things for a tenant in a casualty clause are to also have the ability to terminate, because 9 months to a year is a long time to wait around to get the premises back. So you should also have the ability to pack up and move on if that's the best choice for your business. And the other thing to be aware of is that even if the landlord does restore the space and there's insurance for that, the tenant's going to be responsible for redoing all of its TIs. And if they got an allowance the first time when they signed the lease, they're not going to get an allowance after the building is burnt down. So you want to be really sure that your insurance is going to cover restoring your tenant improvements. And then the other thing to be aware of is that most leases are going to have the landlord passing through the insurance deductible to the tenant as part of the expenses. So that's a question to ask at the outset and maybe state in the lease, the deductible can't be more than, say, $15,000, $25,000. The tenant will pay whatever their proportionate share of that is. The tenant should get a rent abatement, full rent abatement for whatever time they're unable to use the space. And that should be true on a proportional basis. If half the space burns down, you should get 50% rent abatement. And on that point, I just say one final thing. Keep in mind that not all space is equal. Some space is, more storage oriented, dead space. Then you've got your production space. If that's what is affected, you're out of business, and a 50% rent abatement is not going to compensate you if you're shut down. So, consider maybe wording that slightly differently, that the rent abatement is based on the impact to your business versus the square footage that's affected.
And it sounds like I need an insurance lawyer and a real estate lawyer at the same time.
Well, yes, I would say you want to have both the insurance clause and the casualty clause reviewed by your insurance broker at minimum. And yes, if you have an expert insurance attorney who could look at the casualty section as well, that's icing on the cake.
Okay. This series of our search for answers from lawyers is consistent in that we have to have a team of advisors for all of these issues. It's the more the merrier, and it's costly, but I feel like it's worth every penny. So can the landlord limit their obligation to rebuild the premises that burn down?
Yes, and often they do. And they're limited by the amount that it would cost them to rebuild or repair the damage. And that largely depends on the insurance policy. And then most of the leases, I think they have a clause that if the property is damaged at the very end of the lease with 6 months or a year remaining, then there's no obligation for either party to rebuild, and the lease is just automatically terminated. And also I think time limits, if I'm not mistaken. So if it would take the landlord to build, take the landlord to maybe 6 to 6 months to a year to rebuild, then it might as well terminate the lease.
Keep in mind, small point, but on that issue of an automatic termination toward the end of the term, you might have a renewal option. So when I review leases and I see that, I always write in that the tenant can negate that termination by exercising the renewal option. So then you do have, say, another 5 years on the term, and then you look back to the other part of the, is the standard, how much money is it going to cost to rebuild, or how long is it going to take? But the issue is not that you've lost your option because this happens in the last year of the lease.
But even if it doesn't happen at the last year of the lease, winemaking is a time-sensitive endeavor. We have fresh grapes coming in within 3 weeks, and then we have to immediately process them. So how do we make sure if something happens to the building and it needs to be rebuilt, that it happens on our timetable?
Rebuilding a damaged building, especially if the context is there's been a major event like a regional fire or an earthquake, it's really difficult to get the permits, to get the labor, to get the materials. And even the 9 to 12 month standard in real life may not be realistic. And when I've seen these unfortunate events, tenants find temporary space, which I know is a huge hassle to do. But I think that would be what you'd be faced with, and under conditions where, especially for the type of, the specific type of space you're looking for, that there may be very slim pickings if the damage was widespread. I don't have an easy answer for that. But I think that if you have, at least in the back of your mind, a plan B, where would we go? Is there another place in the Bay Area where we could do processing? I actually had a client in this very situation, and he hired me to try and negotiate a different space because his first one was burned down and it was not yet repaired. So it'd be very unfortunate and you'd be scrambling, but there's no magic bullet answer, I'm afraid. Lubna, do you have any other more optimistic insights you could offer on that point?
No, I agree with you. It's a disaster. You might want to just have a termination clause of, for a short period of time, if you can't wait 6 months to a year at minimum. Yeah.
So they requested us to do something with our insurance. I'm not really, I don't really even understand the request. It was something like add them onto our insurance. What is that about?
So most landlords will insist that you add them on as additional insureds on your policy.
So what does that mean?
They're also covered. And
so,
that their insurance then doesn't have to then come back and sue you under subrogation of rights.
Okay, so if I don't do this, then their insurer would sue me?
So if you are not, if they're not on your policy and you're not on their policy, and let's say the fire was caused by the tenant, then the landlord's insurance policy can, yes, under subrogation of rights, sue the tenant.
I see.
After having paid the insurance proceeds to the landlord.
So they are asking me something that I should want to do.
Yeah, I think you should also be on their insurance policy.
Oh, I should be on their insurance.
Yeah, that's
okay.
And I would add, it's a fairly simple and routine thing to do. You call up your broker, you ask the landlord for the names of whatever entities affiliate, maybe the landlord and some affiliates, maybe the manager, the property manager. They may want their lender named also. So you'll get a list of 4 or 5 possibly names to put on your insurance, and you call up your broker, and then they send you back a certificate showing all the additional insureds.
I see.
And there shouldn't be any extra cost to that.
And if I ask the same, will they do the same for me, or does this have to be negotiated as part of the lease?
I don't as frequently see tenants named on the landlord's insurance because the tenant carries, the liability policy, and the tenant is supposed to be responsible for everything that happens in the space because you're in the space. So the landlord wants to be named because the landlord's always going to be named in a lawsuit simply because they own the property. The landlord, on the other hand, carries the comprehensive insurance to cover you for fire and building loss and so forth. And you don't get any of that if the building burns down or has damage. The landlord uses that insurance. You hope to rebuild unless their lender requires them to use it to pay down the loan, in which case they'll want to terminate the lease. So I don't see it being a quid pro quo both ways. And even in instances where the landlord does carry their own liability policy, which they often do, I think they're looking at that as their backstop for if, your insurance is inadequate or they start, fighting with you as opposed to being indemnified by you. Lubna, have you had a different experience on that insurance issue? Have you had better luck?
Well, so for triple net leases, I think it's easier to have that cross agreement to put the tenant on the insurance policy of the landlord.
Mm-hmm.
When it's a triple net lease or if it's a standalone building, as opposed to sharing a space with other tenants.
So we spoke a little bit about my operations chemicals, and I understand I have certain liabilities there. But what about the prior use of that facility? I'm a little bit concerned with what the prior tenants left there as we are processing, say, organic wine. Then I need to know what kind of hazardous materials were used by prior tenants on the premises. So how can I make sure that my premises are free from these materials when we take possession?
So your first step is get an environmental consultant to do what's called a phase 1. And what that does is goes through the, legal records and the history of the building and the geographical area where you are. It'll tell you what the prior uses of the building have been, whether any open actions or closed actions, for remediation are present with the property, and whether there are nearby sites, depending on the gradient, where hazardous materials could migrate to your property. And if you find that there's nothing of concern there, you needn't do anything more. If you do find that there's something of concern there, then you have to dig a little deeper, no pun intended, do what's called a phase 2, which may entail actually taking samples of soil or groundwater. It may entail monitoring over a period of time. I think that if you, for your type of facility where you're going to be creating wine, if you find yourself in a site where there's been a contamination that hasn't been completely resolved, then you probably better bet is to find a different site rather than get into, trying to evaluate, with sampling whether this can work for you, because that is costly and landlords don't like it. But that's the due diligence process. If there's any question about whether there's been a spill, tanks can also be an issue. If there's underground storage tanks, they might leak. So you want to be looking out for that.
So Lubna, I have an interesting question for you then to close this up. What if we are shut down again and we as much as wine is an essential thing in this pandemic, I don't think I can qualify our operations as essential business, except in so far as somebody needs to go in and babysit the wine. Because I think making food and drinks is still essential. I don't know, but what happens if we get shut down? What happens if I can't make rent because I can't do any business?
So that's a topic that came up very frequently in the past few years. And in leases, there's a clause almost in all the leases with a force majeure clause, so which provides for suspension of non-financial performance during periods of strikes or pandemics and things of that nature. But it's really difficult to completely terminate a lease unless you've completely lost the business, unless it's absolutely difficult and impossible or unpractical to carry on your business. I have not had much luck in negotiating a termination of the lease because the tenant could not pay rent.
Mhm.
So Myra, have you had any better luck?
I would agree, during the pandemic, some, not all landlords were willing to afford some relief. Often it had to be paid back. They defer rent for a few months and they wanted it paid back. Some were willing to reduce rent by half. I mean, it was just a case by case thing. And now that the dust has settled somewhat on the pandemic and tenants are very sensitive to this issue and they're trying to negotiate, expanded force majeure rights and the ability to stop paying rent if there's a mandated government closure, and landlords are resisting. So I'm only seeing maybe in about, I'd say 15 to 20% of the leases I negotiate where landlords are open to pre-agreeing to that relief. But like any other issue we've talked about, the time to ask is now at the letter of intent negotiating stage. And you do have to ask. You have to ask for everything you want, because if you don't ask, then the answer is automatically no. And also, if you put issues on the table, it gives you some ability to horse trade things. And as you get closer to finalization of the lease, you can try and narrow it down to your 4 or 5 or 6 most important issues. What are the deal breakers for you? And use the others, as your bargaining chips that you give on some, and hopefully you get some of the others. And that's how the process works.
Right. Lubna, do you have anything to add?
Not anymore.
Well, this was our presentation for today at Business Law 101. Thank you to the fantastic presenters, co-presenters. And please stay sober till 5 p.m. and drive carefully.
Not St. Patrick's Day yet.
No, but I'm a winemaker. I have to
that's
stay
right.
in
Okay,
character.
okay.
Thinking ahead.
Does anybody have any questions? Are we good?
Yeah, I think so.
Okay,
I did not see any
announcements.
questions.
If you have any materials, speakers to send me, please do so, and I will get those out, and we will go from there.
Oh,
Thank you,
hold
everyone.
on a second. I wanted to share this PowerPoint page that I lost, and I found it.
If
So
you
here-
must.
I must. I worked on it. So there it is.
Oh, yeah.
There it is. Here we go.
There's Myra. All right.
Yeah. Thank you, everybody.
Thank you, everybody. Thank you, Myra. Thank you, Lubna. Thank
Yeah.
you,
Thank you
Marta.
very much.
Thank you. Bye-bye.
Good
Bye.
afternoon, everyone. Bye-bye.
Thank you.